11. Basic structure of the Constitution. Emergence of the basic structure. The question whether fundamental rights can be amended by the Parliament under Article 368 came for consideration of the Supreme Court within a year of the Constitution coming into force. In the Shankari Prasad Case 1, 1951, the constitutional validity of the First Amendment Act, 1951, which curtailed the right to property, was challenged. The Supreme Court ruled that the power of the Parliament to amend the Constitution under Article 368 also includes the power to amend fundamental rights. The word law in Article 13 includes only ordinary laws and not the Constitutional Amendment Acts, constituent laws. Therefore, the Parliament can abridge or take away any of the fundamental rights by enacting a Constitutional Amendment Act, and such a law will not be void under Article 13. But in the Laxmikanth Case 2, 1967, the Supreme Court reversed its earlier stand. In that case, the constitutional validity of the 17th Amendment Act, 1964, which inserted certain state acts in the 9th schedule, was challenged. The Supreme Court ruled that the fundamental rights are given a transcendental and immutable position, and hence, the Parliament cannot abridge or take away any of these rights. A Constitutional Amendment Act is also a law within the meaning of Article 13 and hence, would be void for violating any of the fundamental rights. The Parliament reacted to the Supreme Court's judgment in the Laxmikanth Case, 1967, by enacting the 24th Amendment Act, 1971. This act amended Articles 13 and 368. It declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368, and such an act will not be a law under the meaning of Article 13. However, in the case Vanandabati Case 3, 1973, the Supreme Court overruled its judgment in the Laxmikanth Case, 1967. It upheld the validity of the 24th Amendment Act, 1971, and stated that Parliament is empowered to abridge or take away any of the fundamental rights. At the same time, it laid down a new doctrine of the basic structure, or basic features, of the Constitution. It ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. This means that the Parliament cannot abridge or take away a fundamental right that forms a part of the basic structure of the Constitution. The doctrine of basic structure of the Constitution was reaffirmed and applied by the Supreme Court in the Indira Nehru Gandhi Case 3, 1975. In this case, the Supreme Court invalidated a provision of the 39th Amendment Act, 1975, which kept the election disputes involving the Prime Minister and the Speaker of Lok Sabha outside the jurisdiction of all courts. The court said that this provision was beyond the amending power of Parliament as it affected the basic structure of the Constitution. Again, the Parliament reacted to this judicially innovated doctrine of basic structure by enacting the 42nd Amendment Act, 1976. This act amended Article 368 and declared that there is no limitation on the constituent power of Parliament and no amendment can be questioned in any court on any ground including that of the contravention of any of the fundamental rights. However, the Supreme Court in the Minerva Mills Case 4, 1980, invalidated this provision as it excluded judicial review, which is a basic feature of the Constitution. Applying the doctrine of basic structure with respect to Article 368, the court held that, since the Constitution had conferred a limited amending power on the Parliament cannot under the exercise of that limited power enlarge that very power into an absolute power. Indeed, a limited amending power is one of the basic features of the Constitution and, therefore, the limitations on that power cannot be destroyed. In other words, Parliament cannot, under Article 368, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic features. The dunny of a limited power cannot by the exercise of that power convert the limited power into an unlimited one. Again in the Vaman Rao Case 5, 1981, the Supreme Court adhered to the doctrine of the basic structure and further clarified that it would apply to constitutional amendments enacted after 24 April 1973, i.e., the date of the judgment in the case Vanandabati Case. Elements of the basic structure. The present position is that the Parliament under Article 368 can amend any part of the Constitution including the fundamental rights but without affecting the basic structure of the Constitution. However, the Supreme Court is yet to define or clarify as to what constitutes the basic structure of the Constitution. From the various judgments, the following have emerged as basic features of the Constitution or elements of the basic structure of the Constitution. 1. Supremacy of the Constitution. 2. Sovereign, democratic and republican nature of the Indian polity. 3. Secular character of the Constitution. 4. Separation of powers between the legislature, the executive and the judiciary. 5. Federal character of the Constitution. 6. Unity and integrity of the nation. 7. Welfare state, socio-economic justice. 8. Judicial review. 9. Freedom and dignity of the individual. 10. Parliamentary system. 11. Rule of law. 12. Harmony and balance between fundamental rights and directive principles. 13. Principle of equality. 14. Free and fair elections. 15. Independence of judiciary. 16. Limited power of Parliament to amend the Constitution. 17. Effective access to justice. 18. Principles, or essence, underlying fundamental rights. 19. Powers of the Supreme Court under Articles 32, 136, 141 and 1426. 20 Powers of the High Courts under Articles 226 and 2277. Table 11.1 Evolution of the basic structure of the Constitution. SL. No. Name of the case, year, elements of the basic structure, as declared by the Supreme Court. 1 Keswananda Bharti Case 3, 1973, popularly known as the Fundamental Rights Case. 1 Supremacy of the Constitution. 2. Separation of powers between the legislature, the executive and the judiciary. 3. Republic and democratic form of government. 4. Secular character of the Constitution. 5. Federal character of the Constitution. 6. Sovereignty and unity of India. 7. Freedom and dignity of the individual. 8. Mandate to build a welfare state. 9. Parliamentary system. 2 Indira Nehru Gandhi Case 3A, 1975, popularly known as the election case. 1 India as a sovereign democratic republic. 2. Equality of status and opportunity of an individual. 3. Secularism and freedom of conscience and religion. 4. Government of laws and not of men, i.e., rule of law. 5. Judicial review. 6. Free and fair elections which is implied in democracy. 3 Minerva Mills Case 4, 1980, 1. Limited power of Parliament to amend the Constitution. 2. Judicial review. 3. Harmony and balance between fundamental rights and directive principles. 4 Central Coalfields Ltd. Case 8, 1980, effective access to justice. 5 Bhim Singh Ji Case 9, 1981, welfare state, socio-economic justice. 6 SP Sampath Kumar Case 10, 1987, 1. Rule of law. 2. Judicial review. 7 P. Sambamurthy Case 11, 1987, 1. Rule of law. 2. Judicial review. 8 Delhi Judicial Service Association Case 12, 1991, powers of the Supreme Court under Articles 32, 136, 141 and 142. 9 Indra Sohni Case 13, 1992, popularly known as the Mandal Case. Rule of law. 10 Kumar Padma Prasad Case 14, 1992, independence of judiciary. 11 Tihoto Holoho Case 15, 1993, popularly known as defection case. 1 Free and fair elections. 2. Sovereign, democratic, republican structure. 12 Raghunath Rao Case 16, 1993, 1. Principle of equality. 2. Unity and integrity of India. 13 S.R. Bomai Case 17, 1994, 1. Federalism. 2. Secularism. 3. Democracy. 4 Unity and integrity of the nation. 5. Social justice. 6. Judicial review. 14 L. Chandra Kumar Case 18, 1997, powers of the High Courts under Articles 226 and 227. 15 Indra Sohni 2 Case 19, 2000, principle of equality. 16 All India Judges Association Case 20, 2002, independent judicial system. 17 Kuldeep Nair Case 21, 2006, 1. Democracy. 2. Free and fair elections. 18 M. Nagraj Case 22, 2006, principle of equality. 19 IR Koilhon Case 23, 2007, popularly known as 9 Schedule Case. 1 Rule of law. 2. Separation of powers. 3. Principles, or essence, underlying fundamental rights. 4. Judicial review. 5. Principle of equality. 20 Ram Jethmalani Case 24, 2011, powers of the Supreme Court under Article 32. 21 Namit Sharma Case 25, 2013, freedom and dignity of the individual. 22 Madras Bar Association Case 26, 2014, 1. Judicial review. 2. Powers of the High Courts under Articles 226 and 227. Notes and references. 1 Shankari Prasad v. Union of India, 1951, 2. Golaknath v. State of Punjab, 1967, 3. Keswananda Bharti v. State of Kerala, 1973. 3 A. Indira Nehru Gandhi v. Rajnarayan, 1975, 4. Minerva Mills v. Union of India, 1980, 5. Vaman Rao v. Union of India, 1981, 6. For the subject matter of these articles, see Appendix 1. 7 Ibid. 8 Central Coalfields Limited, v. Jaswal Coalco, 1980, 9. Bhim Singh Ji v. Union of India, 1981, 10. SP Sampath Kumar v. Union of India, 1987, 11. P. Sambamurthy v. State of AP, 1987, 12. Delhi Judicial Service Association v. State of Gujarat, 1991, 13. Indra Sohni v. Union of India, 1992, 14. Kumar Padma Prasad v. Union of India, 1992, 15. Kihoto Holoho v. Zachailu, 1993, 16. Raghunath Rao v. Union of India, 1993, 17. S.R. Bomai v. Union of India, 1994, 18. L. Chandra Kumar v. Union of India, 1997, 19. Indra Sohni 2 v. Union of India, 2000, 20. All India Judges Association v. Union of India, 2002, 21. Kuldeep Nair v. Union of India, 2006, 22. M. Nagraj v. Union of India, 2006, 23. IR Koilhon v. State of Tamil Nadu, 2007. 24 Ram Jethmalani v. Union of India, 2011. 25 Namit Sharma v. Union of India, 2013, 26. Madras Bar Association v. Union of India, 2014. Part 2 System of Government. 12 Parliamentary System 13. Federal system 14. Center-state relations 15. Interstate